And so we're going to start with what I think is the most important and yet underutilized stage of a child protective case, which is the preliminary hearing. I think the reality that we see is that the removal process, not just in Michigan, but all over the place, is at times somewhat arbitrary, that we both over-remove and under-remove. There's certainly kids in foster care who may not need to be there. And you see lots of spikes over time when something bad happens. For example, I used to practice in Washington, D.C. Whenever there was a child fatality, you would see the number of kids in foster care just skyrocket. And you'd have a lot of defensive social work where people over-remove children simply because of fear of liability, fear that they'd be in the newspaper, and you'd get kids who didn't necessarily need to be there enter foster care. So I'm writing a paper right now on the removal process, and one of the stats that was really astonishing to me is that across the country, there are about 25,000 kids in foster care who go home within 30 days. So they're removed and they're sent home within 30 days. The majority of those kids are returned within 6 days. And so we have a lot of children who are being taken away from their parents. Not so much in Michigan, fortunately. This is actually a problem in a number of states. We're not high on that list. But that's about a tenth of all children removed each year. There's about 250,000 kids removed and put in foster care each year. About 10% of those kids go home within 30 days. And so for me, that's not a good thing. If the kid can go home within 30 days, we should really be sort of looking as to why they were removed in the first instance. And as advocates, one of the stages and the steps that we have to really make a difference is that first removal hearing, the preliminary hearing. But what's the reality for many of us, right? I do work in Flint, in Washtenaw County. We've done work in Detroit before. And that preliminary hearing, as grand as it's supposed to be, often fails to live up to the reality, right? It's rushed. It seems sort of perfunctory, sort of just going through the course. They are short in many counties. They're quick. They're emergency driven, and at times it's tough. It's a tough environment to lawyer in if you're a parent's lawyer, because judges may wish to, because they don't know much about the case, simply to push it to another hearing where perhaps they can collect more information about the case. And one of the things that we want to emphasize is that's not necessarily the way the law is written, the way that the law should be utilized, because there are certain findings that judges have to make that as parents' attorneys, it is our job to make sure that courts are forced to make those types of findings. One of the reasons I care so much about the removal process is that it dramatically changes everything about a case. An example is a case in Washtenaw County that I had just a couple of months ago where we had a removal hearing, pretty significant allegations, but the GAL in that case argued against removal, and the referee decided not to remove. And we represented the mother in the case, and that decision not to remove completely changed the trajectory of a case in that we were able to work with the family, get services in the home, and we had that case closed by disposition. In the same way, if that kid had been removed, it just changes everything. It changes the dynamic of the case, the relationship between the parties, the relationship between the child and the parent. That is not to say that there are not cases that kids must be removed. There absolutely are. But we need to make sure, and as parents' attorneys, we have a prime obligation to ensure that only those kids who need to be removed are the ones actually that are actually removed, and at least we make the arguments that need to be made. So this is just some of the things that over the years have bothered me about some of the things that I have observed, and this isn't just in Michigan, but this is sort of all over the country in terms of how removal hearings are. So they're quick, advocacy doesn't really happen all that much, the oversight of judges over the process is sort of haphazard, and then once kids remain in placement, they continue there, and then it's this uphill battle that as parents' attorneys, it's just this grind, right? Because everything moves slowly then. You got to get to adjudication, then you got to get to disposition, then you got to do that transition from supervised to unsupervised to overnight to reunification. And that's just the way sort of practice has developed over time. And so one of the things I'm hoping is that we can sort of collectively as a group think about ways that we may be able to change that dynamic a little bit. Some of the stuff, and this is all in your packet, but if you look at the best practices, and this is from the organization that that deals with juvenile court judges, they recommend something far different than what we see in practice. And they sort of flip it. If you think about the way we do our hearings, the most meaningful hearing in terms of length and substance is that termination of parental rights hearing. When we spend all of a sudden like getting time on a docket, you can get, you can call witnesses, we're going to really sort of thoroughly consider the decision. But honestly, at that stage of the case, it's almost like we're just dotting our I's and crossing our T's, because if it gets to the termination stage, the conversation is likely headed in one direction. If you look at best practices all over the country, what they recommend, and nobody does this well, so this isn't sort of an attack on what we do, they often say that the preliminary hearing is by far the most important hearing in a case. There's a judge who trains quite a bit named Len Edwards, who has come to Michigan before. He often says the preliminary hearing is the most important hearing. They recommend dedicating up to an hour for such a hearing. It's just yet one more example in the child welfare system that if we flip some stuff around, we could actually make a dramatic impact in what we do. If we lengthened that preliminary hearing and made it far more meaningful, perhaps we would have fewer kids in foster care, which would create more space for all of us to do this work better. And so this is just a quote from Judge Edwards that of how much that we can accomplish at the initial removal hearing. All right, so one of the things that I think Tracy and I are going to emphasize throughout the day is that our laws and our DHHS policies are actually really good as it relates to supporting and protecting the procedural rights of parents. That the reality that we're looking for is not, our job is a little bit easier in that we're not trying to change the law in most instances. That we can, if the laws were enforced as written, if DHHS policies were enforced as written, we would have a completely different child welfare system. And so one of the things we want to do today is just have you walking out of the room feeling confident that you know what those are and that you know who to ask if you don't know what those laws are and policies are. So we're just going to kind of go through. It's a little dense. If people have things to add on that we missed in these PowerPoints, please just jump right in and say them. If you have questions or comments as we go along, please, we don't need to wait till the end of anything to do that. We're hoping for a back and forth throughout the day. And so let's just go through it real quickly. So at the preliminary hearing, what are the main things that happen? First, you have this question of whether the petition should be authorized. Second, you have this question of where this child must be placed pending the duration of the case. Third, you have this question of services and whether the parent can engage and should engage in services immediately. And then finally, you have this question of reasonable efforts. Did the agency make reasonable efforts to prevent the removal prior to removing the child from the home, or was this what they call an aggravated circumstance case in that reasonable efforts did not need to be made in the case? All right, so you get, in most counties across the state, you have, as parents' attorneys, very, very, very little time to do anything before a prelim, right? You get there, they're docketed at 1:30, you get there at 1 o'clock, you're handed a piece of paper, you have a sort of the waiting room full of clients, you're yelling their name out, trying to figure out who they are, and you don't have much time. Now, it varies from county to county, but that's often the reality, that you don't have very much time. One of the things you need to think about is how do you spend that time? Right? What can you mean? And we're going to do a little simulation at the end of this presentation just to get us thinking about what types of questions and information we can get in a very short period of time to try to make our advocacy meaningful in this. First step, this sounds obvious, but you want to talk to your client. Right? Part of what you want to do when you're handed a petition, you are handed the department's version of what happened. And as parents' lawyers, one of the things that you have to do throughout the duration of the case is develop that counter narrative, which is what is the other story. And there always is another story. Life is much more complicated than one person's perception of of what happened. And so part of what you need to do is talk to your client and don't start necessarily with what their version of the facts are, but just get the other story. Get your client's story of what happened the day of the incident and what happened sort of in a broader sense with this family, like what is going on. I would also be thinking about your investigation, right? So the preliminary hearing is just the beginning usually of a case. You want to think about who else you need to talk to fill that narrative. One of the things I would definitely do is bring just blank releases to a hearing. Your client is there often after the hearing. It is tough to track them down. If you need a sample blank release, just send me an email. We have them sort of ready and we're happy to share them. And what we do is just write down client's name, service provider, get them to sign it. And that way, after the hearing, we don't have to go tracking down our client to get in contact with the doctor or the teacher or the therapist or the people that the client may have been working with prior to the duration of the case, and we can start investigating the case right away. I would try to talk to as many people as you possibly can before the prelim. So you want to try to seek out the Attorney General or the County Prosecutor, the GAL, just to grab them and spend the 20 seconds they may have before the hearing starts to see where they are and whether there's any chance that you can negotiate a possible solution in the case. You want to gather relevant documents. Again, at the prelim, it's going to be very hard because no one knows anything about what's going on, right, except for the CPS worker. And so anything you can get your hands on. If you're in the courthouse and you have some spare time and you can run a criminal check, or if there's a domestic violence issue, go up and see whether there were any protection orders, just to get whatever comprehensive sort of information you can get heading into that hearing. The more information you have heading into that preliminary hearing, the more you'll be able to advocate on behalf of the client. So I find that of my client meetings, the ones before the prelim are often the hardest, because you have a client who is in severe, has experienced a severe traumatic event in that the worst thing in their life has happened to them. They've had their kid removed. They are stressed. They have the sort of the hustle and bustle of the courthouse. They have the stress of about to appear in a court hearing. And so while the initial client meeting is important, I think realistically you need to sort of think about what your goals are in a particular case. This is not going to be your full client interview, and it shouldn't be. You're not going to get as much as you want to. For me, what I try to do is that first thing, which is just building rapport, helping the client understand who you are, what your role is in the process, and that you're here to help them, which for us seems obvious, right? We're appointed to represent them. We're there to fight on their behalf, and yet how many times have we gone in sort of guns blazing, sat down with a client, and we get an angry or hostile client who doesn't really want to talk to us, doesn't really understand what it is that we do. And if you view it from their perspective, we are appointed by the very same court that took their child away. When they see us, when I go down to court is also a time for me to chat up my buddies who are, also practicing down there, and it could include the prosecutor, and it could include the GAL. And I often fail to think about the unintended sort of consequences of how I am perceived. One of my first cases when I was a lawyer in Washington, D.C., involved a domestic violence case where I was representing a survivor in a PPO case. And I sort of met with her, and then I went over to the batterer, and I was trying to get him to settle the case. And so I was just kind of joking around with him and trying to get him to make concessions so that way we didn't have a contested trial. I got him to do it. I came back, and she was livid by seeing this image of me and him smiling and laughing and having a conversation. Here I was, naive to think, we got a settlement. Like we got exactly what you wanted. But for her, that image of seeing me sort of cozy with the other side was very difficult. And I fear that in child welfare cases, especially at this initial hearing, where they don't know you for anybody, they don't know why you're doing anything, the clients are often very skeptical about who anyone is in the system. We just need to be mindful of how we are perceived, what we do, and our actions in this initial stage. Basic information that I would get in every case, just contact information. How are you going to meet next? What are you going to do? How do you get in contact with them? I would always ask information about Indian heritage. It is coming up more and more in this state. It is something that we all assume is not going to exist in our case because it doesn't happen in that many of our cases. And yet it's the one thing that can dramatically, and we're going to talk a little bit about ICWA and MIFPA just to sort of go over some of the basic requirements, but it can dramatically affect how the case it proceeds. So just a simple question of, do you have any Indian heritage? Are you a member of a tribe? Do you have any family members who are members of a tribe? It is, there are a couple of hearings that I remember where I just never asked that question, and then at some point, I got a client and her last name was Hawk, and I didn't ask the question of whether she was Indian, and so we were at like the termination hearing, and the judge was like, do you have any Indian heritage? And she's like, oh yeah, I do. And it just delayed everything, right? It just is one of those things that we don't think to ask about, but we need to, because it can delay quite a bit. You want to talk about sort of CPS history, criminal history. Just all you're doing right now is almost figuring out where else are you going to investigate when you leave this, this proceeding. How can you chase down leads? Placement resources. You want to figure out if the kid cannot go home, what are the options? And this is a big one, right? That we need to make sure the conversation cannot only be, can I get this child home today? Because honestly, let's face reality, that's hard to do at a preliminary hearing when a judge doesn't know much about the case and is afraid to send the child home when they have the department's version of what happened and have a CPS worker, and then we are not able to really do all that much to counter that at that moment because we don't have that much information. So part of the conversation needs to be, tell me about your relatives, tell me about your friends, tell me about whoever lives in your neighborhood that may be able to take this child in. So at least you can start suggesting that at the preliminary hearing. Other things, work with service providers, names, phone numbers. You want to get as much detail as you can, get those releases signed, so that way you can go directly to those people and chat with them after the hearing at some point. And Tracy's going to be talking in the next segment about post-preliminary hearing, the next 60 days, the types of things you should be doing. And high up on that list is just a basic investigation like you would do in any criminal case, civil case. We have to be doing it in these cases as well. So what are the, so as I think of client meetings, there's the interviewing aspect of the meeting, and the interviewing aspect often involves building rapport, us giving the client information about what's going to happen next, right? So part of our role as lawyers, we often think of sort of interviews as opportunities to get stuff from clients. But an important part of that process is also giving stuff to clients, giving them information about what this all means. Many of my clients think that the prelim is their chance to have like a full-blown trial. They're like, I'm ready, I got my witnesses, this is it. And they don't often understand that this is a process. And so just showing them the process, we have a flow chart that we use with a lot of our clients. It just shows like in boxes, like prelim, pre-trial, trial, dispo, review hearing. So that way they can just see the arc, that these are the different stages of the proceedings. That just helping them understand sort of how this fits in to what is happening with their family. But you also, and this is incredibly challenging, you also have a very short time period to do some client counseling. And you have to do some client counseling. There are far too many situations where I've seen where lawyers who represent parents simply go, oh, we're going to waive authorization, we're not going to challenge removal, you're going to have a right to a trial someday, and you'll have a chance to do it, but that's what we're going to do. Right? So the essence of what we do as a profession is we're a service industry, right? We are here to serve our clients, and at the heart of that is being client-centered, which is that we are here to make sure that what they want and what they seek in this case is presented to the court. And that involves us having a conversation with them. Now the conversation could go something like, and we'll talk a little bit about some of the considerations about when you challenge authorization and stuff like that. But it has to be something like, here's the reality, here's the situation, here's what I recommend, but I'm here to let's talk about it. Like what would you like to do and why? And really have a conversation with your client about how they would like to proceed. The issues that you need to go over with them: authorization, placement services. Are they willing to accept services and conditions? Parenting time. What do they want to do? Do they want to? Are there other options that they can think of if visits need to be supervised, other than the 1 hour a week at the department or 1 hour 3 times a week at the department? Are there relatives, family members, places in the community, church members, people who could supervise visits? That would be helpful. And then going over what's next. Again, that flow, right? What's going on? The fact that they do have a right to a jury trial later on, a right to a trial if they want to get their story heard. They absolutely have that opportunity. The prelim, though, they have to, I think, understand it's an emergency-driven process that is not going to make them feel like they've had a chance to hear their story. So one of the things that's tough, right? A lot of people complain that, my hearings are called, I don't have enough time. And I think that's where, as lawyers, we just have to start being willing to ask for stuff. And we have to start saying to a court, if you've only had a minute and you haven't had a chance to talk about whether your client wants to waive probable cause, you're not prepared for the hearing yet, and you need to ask for more time. Another theme that you're going to hear from me and Tracy throughout the day is we need to start asking for stuff, even if we're not going to get it. Because often the reaction is, my judge never gives us more time because they want to get off the bench and they're not going to give us the extra 20 minutes we need. Or my judge will never give unsupervised parenting time. My judge will never order the agency to do X, Y, and Z. Part of the way you change practice and culture is by asking for stuff, getting denied over and over and over again, but then getting your colleagues in the same community to start asking for stuff, then getting the appellate lawyers in your community to start realizing that you're asking for stuff and raising things at the Court of Appeals, and then you start seeing things slowly change over time. It is not something that's going to change overnight. People may get a little bit annoyed at you, but our profession is full of good things happening because of people getting annoyed at lawyers, right? I mean, any change starts with people getting angry at those who push a little bit more than they like us to be pushed. And so I hope that we start doing that a little bit more, because again, I do a fair amount of appellate work as well, and oftentimes I look at records where there's just very little pushback. And I understand some of the dynamics in counties where you get appointed by judges and you're afraid of sort of ruffling the feathers, rocking the boat. And that certainly is sort of a broader, complicating issue that I think we need to confront on a systemic level in terms of how we sort of appoint lawyers and some of the bad incentives it creates. But I think fundamentally, sort of our ethics require us that if our client wants something, that we start pushing and making sure that that at least the positions are heard. Yeah, Trace? Yeah, I've also found, just on that note as well, that tone matters a lot. Then if you ask for things in a respectful, civil tone, as opposed to being sort of the lawyer that goes in and screams at everybody and pounds their shoe on the table and frustrates everyone, you may get denied, but judges, in my experience, have not been angry about the ask, right? Your Honor, if I may, we would ask that X, Y, and Z for these reasons. Here's the law, here's the policy. And you do it with a very sort of even keel, level-headed tone. Judges, for the most part, have been very receptive to that, whereas if you seem exasperated and frustrated and angry and raise that same argument, you're much more likely to get pushback. So this is some of the stuff just in the law. Timing for the prelim, it has to happen 24 hours. The court can adjourn a prelim for up to 14 days for the attendance of witnesses or good cause. But even if the prelim is adjourned, the court has to, at that first hearing, make a decision about placement, right? Which makes sense because the kid needs somewhere to go in the intervening time period. Yeah.
Yeah, it didn't have the parent side.
Yeah, I agree. So what happens in a lot of counties now, and Detroit, I know a bunch of people from Detroit, and this isn't an issue here in Detroit usually because there's people on call for dates, where there's for the prelim. And so you often have lawyers at the courthouse on the days of the preliminary hearings. In many counties, so Washtenaw County is an example of this. They will have the prelim, parent shows up, asks for a lawyer, so then they'll continue the prelim to another date, but then in the intervening, sort of that first order, they're still making findings, they're still placing the kid in foster care, the prosecutor's there, the GAL is there, and then you have really no ability for the parent on that first day of the prelim to push back on placement.
Yeah, our county
Right, unless...
is not even there. They don't have any attorneys there.
Yeah, that's...
It's parent and jurist.
Yeah.
And CPS.
So I think, I mean, so without a GAL there, I think that's a clear violation of the statute. Unfortunately, the way the statute's worded as it relates to parents' attorneys is that the first appearance, the parent can ask for the attorney, and then it allows them to continue the hearing for 14 days for good cause shown, but then they're allowed to make these interim decisions. So it's a great point. I think as a parent's lawyer, what would you recommend, Betsy, that you, when you get appointed, that you ask to revisit the issues? So just, and this goes to Tracy's point about the different decisions that need to be made. So one is authorization, right? And so this is the basic question of whether this case can even move forward. And the standard for authorization is both the showing of probable cause, so it's a very low standard at this initial stage, that one or more of the allegations are true, but there's this big and, which is and fall within the provisions of Section 2B of the Juvenile Code, right? So if you had a petition that said, it is sunny outside, well, that would be a true fact today, but clearly it doesn't fall within the provisions of 2B of the Juvenile Code. It doesn't give rise to abuse or neglect. There is that language in the code that the court should determine whether the petition should be dismissed or referred for alternate services. In a case where that may be appropriate, that is something that you can ask the court to do, which is almost this inherent authority that the court has just to make a case go away if the court doesn't seem like the case should go forward.
They have to do it if they cannot prove that they provided reasonable efforts to prevent removal in a non-aggravated case, because there's other provisions that says you can't even enforce disposition orders
Without reasonable
if you
efforts.
didn't provide prevention efforts. I mean, you can unravel it.
Yeah.
So that's where I get in and say, okay, I want to go through these reasonable efforts list, because frankly, the majority of them are completely false.
Yeah.
If you ask your client, have you ever had this long laundry list of services provided to you for this removal? Every one of them will say, I don't recognize almost everything on that list.
So let's hold off on reasonable efforts because we're going to get there,
Yeah.
because I think that's an area that we need to start advocating as well.
Services, put them back into reasonable efforts.
So the first thing as a lawyer you really need to, or the first sort of legal decision you need to think about is authorization, right? Whether you encourage, counsel, suggest to your client to challenge the authorization of the petition or not. This is some of sort of my thought process as to when I would challenge authorization, although I'm curious to hear what you all think as well. So first, in the back of my head, I'm thinking standard of proof is very low, right? Probable cause, which is reasonable ground for belief. The rules of evidence do not apply. So in reality, what that means at this hearing is that you will have the CPS worker or a cop or somebody just get up and recount from start to finish what they did in their investigation, and they can cite all sorts of hearsay. Having the jurist hear all that stuff as opposed to seeing it on paper may have a much more visceral effect on him or her in terms of what they want to do in the case. Having a contested hearing for authorization may also delay a decision on sort of removal placement. They may just want to, it's hard to say I want a probable cause hearing, but then ask for the child to be removed pending that hearing. A judge may say, well, I want to hear all the evidence that you're going to present, so I'm not going to necessarily make a determination on removal. You have an opportunity for a full-fledged trial. So my view has always been that if there's serious sort of factual disputes in a case, I personally sort of shy away from the removal, from the authorization hearing. And that's separate from the placement hearing, two completely separate issues. I've always asked for an authorization, a probable cause hearing, when I think that even if true, the facts don't necessarily rise to the level of 2B. But I know that Betsy probably disagrees with me, because I see her shaking her head.
But I'll have to say this is kind of limited in some measure to retained attorneys, because they sometimes like out as more winnable cases because you pick them. However, no, I rarely waive probable cause, and most of my colleagues who do retain one do not. And that's because we don't have depositions in juvenile cases. So we use the probable cause hearing but you're going to get more information that you are not getting from your client, from the agency, and things of that nature that you're going to need. And sometimes, you know, cases fall because of it.
Yeah, so I think the tension for me is, while I totally agree with you as a discovery mechanism, it can be effective. The other people who get that information it's not just us, it's the jurist, it's the other parties, and I worry that having that full-fledged hearing where there are no holds barred, exposes all this information to everybody, and I think there's a downside to that. And so I totally get it. Like, I think there's an upside to it. It's one of those, you just have to weigh the risk and see how helpful it is. For me, you know, information in these cases are pretty, I mean, with the reports that are generated, we have pretty broad discovery rules that I'm not sure I would take that same risk, but I think it depends on the case, and I think it depends on the attorney and what they want to do. Kim, what do you do?
Well, I just wanted to point out that the other downside is that you don't have a right to remain silent, and your client can be called to testify, and oftentimes you might be.
Yeah, I mean, in Washington, it's often the first or second witness they call at a preliminary hearing.
At that hearing, because it's not going to hurt you to assert the fifth. It's not like taking it.
But only if you have, only if there's some criminal charge. You don't have a Fifth Amendment right in any case, only if you know that there's going to be a criminal charge.
I also think there's I mean, in our world, for better or worse, there's sort of the power of perception and how a client is perceived in terms of, by the agency, to create momentum. And I think it's one of the things that makes our world difficult to lawyer in that in a criminal case, because it's all about historical facts, you can, I mean, like this, we wouldn't be having this conversation. Of course you ask for a preliminary hearing, because it's not about future sort of actions, and you're not creating a record prospectively. You're just adjudicating, did this happen, didn't this happen, does this rise to the level of a criminal statute? Here the problem is you have all the past stuff, but then you have all these decisions that are still being made about your client. Do they have to get to see their kids? Do they get to visit them? Do they get reunified with them? And so we rely on the agency and the court to make those future decisions. And so as you're thinking about lawyering decisions in a case, part of what you need to think about is, how is this going to affect things moving forward? Whereas in other areas of the law, there is no moving forward, because you're just going to have a trial on whether the thing in the past happened. For us, that trial in the past, the adjudication trial, is just the first step in many cases, because if you lose, then you got to go start talking about the future. And so every decision you're making, you have to think about in your case, you know, how is it going to hurt my client moving forward? It is not as easy as saying simply, I'm going to assert the fifth, I'm going to ask for a hearing, because while that may have a legal right to do that, then you might get the judge and the worker saying, well, I'm never returning this kid home, so long as this is a parent who's unwilling to admit that they have issues, whatever that may be. And whether that sort of perception, that judgment is right or wrong, it's the reality that we often face. And so I think with this question, with the question of whether you plea or go to trial, all of these things I think are impacted by momentum and what you think is going to happen in terms of sort of speeding your momentum or not. Kim? And so Kim, if I could just say,
so the prosecutor didn't call him.
well, one of the things I think that's important that I wanted to make sure Kim, that people sort of saw in her message was how she sort of advised her client. The important thing that I get out of it is that clients need to know that whatever you say to the agency, whatever you say to your therapist, whatever you say at the evaluation is going to be used in a broader sense, that they may not understand that. Kim's clients, sort of come in thinking everyone is here to help me, but there is this sort of looming termination and, and other things that may come into play. That what I heard Kim saying right there is she sat down with her client and said, if you start doing services, if you go to that evaluation, you should know that it exposes you to this risk, that they may use this all over the place. And then the client said, yes, but I'd still like to do it. Which is their right? We are, again, this idea of client-centered lawyering. Our clients have the right to make bad choices. They can disregard our advice. They don't have to do what we tell them to do in all circumstances. And many a times, what we may think is the right course may not be sort of the best course of action. The client may know some of the dynamics that we may not, But I think it is important, especially at this sort of early stage, that clients know right away that we are the one sort of entity out there that if you tell us stuff, we can't tell other people. Everyone else, you got to do it.
That's unusual, like you mentioned earlier, is that then the client will say, well, should I talk to them at all? And I don't advise clients not to do that because cooperation can help you down the road. This is just, we're at the preliminary hearing, we are just at the beginning stages. But there are attorneys that do advise their clients not to talk to. I limit what it is. I try to explain to them, you can talk about, you know, the medical history for your children and that kind of thing. You don't talk about the case, don't talk about substances, you know. I try to give them an idea of how to navigate. But it's really difficult. I found how difficult it is to find yourself in this situation. Because as the attorney, you cannot navigate everything.
Right.
That's coming at them.
Right. Right.
Just really quickly, I wanted to add that if you do waive the prelim, because there are lots of reasons why you might want to do that, just make sure that the client understands why you're recommending that. Because at the very least, if there's no other harm, if you waive it and they're gung-ho about having it, you've really put a dent in any effort that you would have to undermine. It'll undermine your ability to build a rapport. And that's going to affect the momentum of the case going forward and make it very difficult for you to advise the client going forward. So just make sure that the client knows why it is that you're recommending that you waive it, he or she waives it.
Why would it do that? I'm sorry.
Well, if your client is, remember, this is your client's first opportunity to share their story, or at least they think it is. And they're very anxious to do that, especially if the child has already been removed, which is the case in most instances. So they want to get their story out. You're telling them, no, we don't want to do that today. If you don't explain why there's a risk, you don't make sure they understand there's a risk-benefit analysis that weighs in favor of not doing it, they're not going to trust you going forward.
So I think you just want to make sure that they understand why you are recommending what you are recommending.
Exactly.
That makes sense. And I think that applies at any of these decisions, right? When
I
you're
suppose I would ask folks, like, I don't make that decision. I don't consider that an attorney decision. I advise my client and say their rules of evidence don't apply. They can call you as a witness. There's a low burden. And I even tell them about the jurist. This referee used to be a prosecutor. She will likely find my probable cause. She won't have to make that call. We don't have enough to kick it at this level. So she's going to play it safe. And our fight is at trial.
And all of that took about 1 minute in
That's
your
correct.
but
Well, no,
just
it
going in.
Yeah.
You can say it in 1 minute, they don't necessarily get it. That's a lot to navigate when you're completely emotional and sometimes crying.
Yeah,
But I'm saying to you, do you?
We're not disagreeing.
Yeah.
Do you make that? I don't make that.
I don't think any of us actually makes it, or we shouldn't be making it. What I'm saying is if the prelim is waived, the client should understand why it is that you're recommending or advising that the client waives it, and they should have full buy-in.
And two quick points. Number one, train DHS in your county to respect the attorney-client relationship. And if I said that they can't talk to my client, they darn well better obey that. Because I have it all filtered to me because I've got the time to take the messages. And number two, tell your client under no circumstances do you sign a piece of paper that's presented to you by anybody before the trial.
All the releases.
It all goes through the attorney, because they put blank releases out there to God and country for your clients and personal information. And so you got to make real sure that gets done.
Yeah. All right.
Get no other message.
So let's keep going. So we have the first decision, authorization. Second one, placement. Remember that these are two completely separate inquiries, right? In our laws, you have authorization is one standard, placement is another standard, and so the first step is that even if a petition is authorized, the court does have the authority to release the child under reasonable terms and conditions. So part of what, and this kind of goes to Kim's point a little bit, is part of what you need to have a conversation with your client is what are you willing to do to keep your child in the home? Are you willing for DHS to do, daily home visits? Are you willing for Families First or some sort of service to be put in the home? Are you willing to screen every day? Like, how far are you willing to put yourself out there if it means that this child or children can be returned home immediately? It's part of the conversation that you want to have early on in that initial client counseling meeting. If placement in foster care is being requested by the agency, then the department needs to introduce evidence to meet the standard. And so it's not a question. So this is something that I think a lot of advocacy still needs to be done in Michigan. We have one of the best removal statutes in the country now. It was enacted several years ago after this sort of crazy story of the Mike's Hard Lemonade case in Comerica Park, where a child was placed in Wayne County foster care after his father had mistakenly served him Mike's Hard Lemonade at a Tigers baseball game. It was a total mistake. Everybody who was sort of looked at the case recognized that it was a mistake, but this kid still spent about 48 hours or so in foster care in Wayne County. And at that time, all the standard was for removal was contrary to the welfare of the child. It was a very, very sort of vague, undefined standard. That family was not the typical family we see in the child welfare system. They had power, they had means, they were both U of M professors, they had the ACLU behind them. They went sort of gangbusters in Lansing and wanted to change the statute, and they did, right? They got this great removal statute, which has, 5 different prongs. First, they got in order to put a child in foster care, and again, evidence, right? In many counties across the state, there is no evidence actually presented at these hearings. What you have is unsworn statements by CPS workers who are just sort of saying things, or sitting around a table, and that's the basis of the removal hearing. You have no witnesses called, no testimony taken, no documents introduced, no cross-examination, no direct examination. None of that happens. And I think what the law requires is evidence to actually be taken for a court to be able to make each of these findings. So one, a substantial risk of harm to the child's life, physical health, or mental well-being. Again, not just a risk of harm, but the law requires it to be a substantial risk of harm. 2, that no provision of service or arrangement except removal is reasonably available to safeguard the child from the above risk. 3, you have the old contrary to the welfare standard, which is really sort of for federal funding. They throw in that language. 4, reasonable efforts to prevent the removal. Sort of Betsy's point that one of the requirements the department needs to show is that they made these reasonable efforts to remove. Reasonable efforts are not things, I was in preparing for this hearing and for this training, I was looking at some of my appellate records to see what people had listed in petitions as reasonable efforts. And the things people list for reasonable efforts are insane, right? It's like CPS investigation is a reasonable effort to prevent removal. No, in fact, that actually resulted in the removal. Appearing in court, had an FTM, right? Those are conversations. They're not sort of efforts. Law enforcement is another one that's often in there.
It really helps to prevent a removal.
I have a slide coming up about sort of some of the examples that DHHS itself gives for reasonable efforts. Those are reasonable efforts, like daycare, housing, rent assistance.
Housing could be, and rent assistance could be a reasonable effort if it dealt with
The issue
homelessness.
Totally, yes. So if you look at the policies themselves, they are legitimate, substantive, real. It's exactly what the law intended. But then what you see in practice is people list whatever they want in these orders. Oftentimes at hearings, we don't even talk about this issue. You just see orders generated, and you're cranked out with these findings automatically made. And so part of, I think, what we just need to do, and this is going to take a lot of time, it's not going to happen quickly, is just change the conversation and to really get courts to pause and say, Your Honor, I'd like to address reasonable efforts. Here, they didn't do this, they didn't do that, they didn't make any efforts. Under this standard, that is one of the things they have to show before they can remove a child from a home. They haven't met it. Under our law, you cannot order removal. Yeah, right here.
I have a question about the definition of removal.
children to the other ex-spouse, is that defined as removal?
In a child protective case, like, so there's a divorce case going on, and then the foster care files a.
Post-divorce, and they're cloaking it as a divorce issue when it's actually a child protective issue.
So if it's in the context of a child protective case, and a kid is moved from one placement to another, one parent to another, I do not think our definitions contemplate that as a placement. I look it up when I get a chance, but there's a weird.
Because parents are not placed.
Yeah, I actually think that's an issue that needs to be litigated, because from the parent's perspective, the child has been removed, right? You have taken something, that I have a constitutional.
Since November 2nd.
Yeah. And so, yeah, in the context of but I don't think our rule, all of these standards, my understanding, my reading of the rule is, as of now, that those standards only apply if a child is placed in foster care. I'll double check that during the break.
So outside the home.
Outside,
Out of home, but the original home.
It just says
Placed in the
outside
care
the
of
home.
DHHS.
I do not think.
Supervision.
Yeah, we can check the definition over the break, yeah.
I have an appeal pending with the Supreme Court, so hopefully they'll define that.
I have two questions for you. If you waive the probable cause testimony, because this is some kind of a dilemma that I'm faced with, can you still attack the reasonable effort section that they have in the form of their petition?
Yes.
Okay.
Yes, because the way I would make the argument is that it's a separate requirement in our court rules at the prelim. Reasonable efforts is just listed in a completely separate section than authorization. So probable cause. So you can waive probable cause, which just means the petition's authorized, but the court still has to make a separate finding, separate and apart from authorization in our court rules. And if they're placing a kid in foster care, they have to make a specific finding that reasonable efforts were made before they can put a kid in care. And so I would just, mentally I would just separate them out.
The pre-live rule does not require evidence for probable cause findings,
Correct.
but it does.
For placement.
Placement findings, but
Correct.
if
Yeah.
requested, it should be an if requested at the bottom of that last slide, because if you don't request it, you're not getting it.
Yeah. Do you have a second question, Kim?
That was going to be my second question. And how does the fact that there's already a taking place
Yeah.
order that's occurred already. So there's been some finding in their order to do that. They, check the boxes. And despite the fact that at the preliminary hearing, that referee or whoever doesn't agree with you, that reasonable efforts to prevent removal is throughout the basic hours. So you could bring that up and challenge us pre-trial.
Yeah. And so, no, you're right, though. In most of our cases, there is a order that already exists prior to the preliminary hearing. That's also, if you look at our statutory scheme, it's a significant sort of concern of mine, because it is clear that those orders should only be issued where it was impossible, basically, to have a hearing. It's like if you think of civil litigation, like a preliminary injunction or a temporary restraining order. You only do that when you can prove that you couldn't have a hearing about it before entering that order. And the way our juvenile code is written, it's the same exact process. This standard is even more heightened. It's all of these factors and an additional one, which talks about how having a hearing was impracticable. You couldn't get, it was such an emergency situation that you could not get a hearing before an order needed to be entered. You couldn't have a full-blown hearing, right? So you can imagine kids being, physically beaten by a parent. CPS goes out to the home. They got to act, right? And so there's a safety issue that needs to be addressed quickly. Those are the types of sort of emergency orders. What we see, though, is it's become sort of a culture that in every removal hearing, there's that order already to remove that has taken place. So we have cases where a kid, let's say, has been in the hospital for like a month. At some point in this process, CPS has decided they want to file a petition and remove the child. Kid's going to be in hospital for another couple of weeks. You could have easily have had a contested hearing with the child not in placement yet, because the kid's in the hospital, about whether the child should go back home or go to foster care. And yet courts are still issuing these ex parte orders to remove. Yeah.
Well, now what you gotta, I want to add to this, and it's very important, anybody can email me, I'll give you 2 little pieces of paper that'll resolve the problem. It has been a rule of constitutional law in this circuit since 1982 that we are required by the due process clause to have adversarial removal hearings prior to the removal with counsel present, absent exigent circumstances. That is the rule in this district. It is the rule all over the country. I do not know why Michigan and so many other states violate that basic due process right to a hearing before they take your children. And we all know that most of these cases are not exigent circumstances because the agency was previously involved before they came.
So that's another example, right, of a case where the agency has been working with a family for a long period of time. Parent stops cooperating, they get concerned, they file a petition, and oftentimes there's that ex parte order, and you're like, well, they could have waited, like, wait a day, wait 24 hours, have a contested hearing where the kid has not yet been removed. It changes the decision-making dramatically. If you're a jurist and the kid has already been placed in care, it is a very different question about whether you continue what is already now the new status quo, or if a kid has not yet been placed, you may get jurists much more willing to work with the family in a way. Just so, circling back to the definition of placement, it is a court-approved transfer of custody of a child to foster care, a shelter home, a hospital, or a private treatment agency. So, if you, yeah, so this is an issue that I think just needs to be litigated at some point because our court rules and statutes don't really define what the standard should be when a kid is placed, when CPS takes from one parent to another parent in the context of, or a court.
It's a constitutional issue too. It's kind of like a Sanders violation with the unadjudicated parent who's been accused loses their kid
Without any finding
standard.
needing to be made. Yeah, Paula?
It's sort of like a full faith and credit violation too, because a family law court has made a determination of best interest of the child and decided that custody remains with this parent.
Yeah.
And then CPS comes in and is changing custody to a parent who it wasn't in the best interest of the child to be with.
Yeah, and there's something about this that I think with the state action involved, that it's a state agency coming in and doing this, I think changes that as well. Our court rules just don't have a standard either. I mean, that's a base. We don't have no standard when that happens from changing from one parent to the other. And so this is just an example of a.
DHS goes out and gives literature, you know that, right? To all these non-custodial parents, they say, here's how you go out and change custody.
They do, and they tell
And
parents.
there's a policy and a brochure for it.
And they tell parents if they don't move to change custody, they're going to be failing to protect.
Right.
Tracy?
I just wanted to add that when we're challenging reasonable efforts, we shouldn't argue merely the agency didn't make reasonable efforts. We should explain to the court what reasonable efforts in that particular case should have looked like, tailoring it to the facts of that case. Because the list that is in DHHS
It's hard. That second H it changes things around a little bit. Yes.
There was a Supreme Court memo last week, I think, that came out, or maybe the week before, that talked about removal hearings. It's very hard to navigate, and they put tables in there and everything. But I think the first frequently asked question in there deals with removing the child in other circumstances other than an NA type case.
Oh.
So it might be I meant to print it and bring it along with
Okay.
me. Because it's kind of hard to follow, but I think it deals with it.
Kelly, do you know anything about that or not?
I couldn't get it.
Okay, that would be great.
Just a brief question.
Yeah.
This evidence that you have capitalized, does that require the rules of evidence?
No. But it still requires sworn testimony and documentation and something other than an attorney standing up and saying, this is what the facts are. Which I know in certain counties, I think Wayne does a really nice job of at least having sort of the formality of swearing people in, asking questions, allowing at least building a record that you can challenge. You go somewhere like Flint, and my experience there has been like, we're just talking about it. Right, it's just a bunch of sort of professionals sitting around a table, and there's no process. And then eventually a decision is made about removal. And so.
So if you waive the probable cause testimony, and then
Yes.
Understand?
Yes. And in fact, Betsy's point is well taken, which is we do almost like a flip, which is we have the rules don't actually call for testimony for probable cause. Like a referee can just look at it. I mean, like under the court rules, they could sort of eyeball it and say, or hearing argument. What the evidence in the court rules is called for is the placement decision. And so you can absolutely say you waive probable cause, waive authorization, but then say, I'd like a hearing, though, on placement. And then the burden is on the department to meet that standard right up there, that the department needs to do it. And I've always been struck by even the court shall receive evidence to establish criteria for placement. So it's not even, the court has to do this. They have to have some basis that, and some evidence justifying their decision to put a kid in foster care.
Typically, it doesn't open. It's not a sworn in.
Yeah, and I actually think so I for an appeal a couple of years ago out of Genesee County, because I wanted to challenge this, but it was a homeless family that they removed the kids because they were homeless. So one of my arguments to the Court of Appeals was they never heard evidence, because unless you, and then I looked at I think it's called the Judicature Act, where they talk about like what evidence is, and they say witnesses have to be sworn in. Like evidence is not anything other than that. But the case settled because they just sent the kids back home before the appeal got heard.
How often do you see the evidence consisting of the caseworker looking at the petition and just reciting what's already
It could be.
there and saying, I felt that, I believed that, it was my impression that?
At a prelim,
Making themselves kind of an expert, offering kind of opinion testimony, which is has no foundation and is not really proper, but passing muster with the judge.
so I think at a prelim it happens quite a bit. And I'm not sure, you could try to push back a little bit, but because the rules of evidence don't apply, your hands are tied a little bit at the preliminary hearing. Come trial, that's the step of stuff that we need to really push back on, right? Is if someone wants to offer opinion testimony, they need to be experts and they need to be qualified, and you have to have an opportunity to voir dire them. And I doubt that many of our workers, because for a variety of reasons, would meet the standard for expert testimony, because they often don't come with, some do, but some don't have master's degrees and other things that you would need to be qualified as an expert. So here's sort of the basic rundown. So these are all in our court rules: cross-examine witnesses, subpoena witnesses, offer proofs. You have if you want, so in the cases that Betsy is talking about where you want to have this contested hearing, you have the right to request an adjournment for 14 days to line up, up to 14 days to line up your case. And so and this happens in sort of the criminal context all the time, so they just set another date for the preliminary hearing in a criminal case so that people can get ready for it and call witnesses. You can think about whether you want to do that in a particular case, or whether you just want to wait for the adjudication trial. I think we've talked about some of the pros and cons of doing both of those things. Hearsay is permissible, although they do have this sort of line at the end of it, as long as it possesses an adequate indicia of trustworthiness. So again, there are some limits. It gives a lot of discretion to the judge to determine whether something has that trustworthiness. But you can certainly push back if you want to and say something is not, at least doesn't meet that standard, and it's so far from being trustworthy that the referee needs to exclude it. But it could be a tough burden to meet.
So, can I ask you a question?
Yeah.
In our county, the court had, I don't know what they're doing now because of the new sort of regime, but they had taken the position that DHS has the care and custody of the child, and they do removals or actually replacements whenever they feel they need to. The court has previously said we have jurisdiction, but you have the care and custody of the child, and you have, and as part of that care and custody, you can replace the child. So I wanted to ask you about that. It sounds like that's not true.
And do you mean from foster home to foster home?
Correct.
No, I think.
Relative home to foster home or foster home to foster home. So, and then secondarily,
Or at any point in the case is what you're talking about, like.
And then secondarily, this issue of relatives having prior CPS history 20 years ago,
Yeah, so I'll take the latter first, which is, so let's talk about relatives. So there is nothing in our law that says that relatives can be barred for the reasons that you cited, which is dated criminal history, dated CPS history.
Well, they would say per their manual.
Correct. And so one of the things that we need to educate courts, and some are much more likely to be willing to sort of be educated on this, is that DHHS policies are not the law, right? It is insufficient for DHS to say, we cannot do X, or we cannot. So an example is, like, there's all this stuff about placements with parents, right? They say, well, we can't place a child with his father because 10 years ago he had a conviction for this, and our policy says this. That does not bind a court in any way. And the courts may find it persuasive that some government agency has decided that this is impermissible, but our job is to constantly say that is not the law. Their policies are not the law. Now we need to strategically use their policies when it helps us, because a lot of their policies are in fact very helpful to us. We'll get to some of the parenting time stuff in a second. But on the issue of relative placement, I mean, not only so they're often going to say, you know, the criminal stuff is a bar. They're going to say that the relatives are not licensed, so they can't be placed with them. Central registry listing, and so none of those. Yes. So there's two different issues. One is to actually. So that's a great point. So I think the first bar is to say, if someone says policy prevents us from doing X, your answer should be show me the policy. Right? So if you look at licensing, for example, they will say you have to be licensed to do it. You look at the policy, it's not true. So you may be able to sort of resolve that, you know, by sort of arguing that it's not even their own policy. But even if it is, you still have, you can go to the court and say, well, you can still do this. CPS history is a great example. So right now I have a case in Washtenaw County where they have stated that a child cannot go with a relative, DHS, because of prior CPS history. But then you ask the worker, who's from a private agency, well, what's that history? And they'll say, we don't know. So now we're in this sort of wild goose chase trying to figure out, and fortunately our jurist has bought into this notion that she's not bound by this. And so now she's issued orders saying you got to produce the CPS history of this relative so we can, and it makes sense, right? Someone 20 years ago when they were a teenager gave up a child because they couldn't do it and they ended up on central registry. That is very different than 2 years ago they were convicted of sexual abuse, right? Like, and so we need to know more, and part of our job as parents attorneys is we got to dig deeper when they come back with these answers to just ask, like, what is it? What are the facts? Why? Like, what does that actually mean?
And what does that history mean?
Yeah.
Because just yesterday I was at an FTM where it was just thrown out, well, grandmother who was trying to keep placement of children, grandmother just picked up a CPS investigation. But she hadn't actually. Someone called in and it was rejected. They didn't even investigate.
Yeah.
It didn't even meet
Yes.
the level.
So,
But if I hadn't asked the question, well, what are you basing this on?
Yes.
What are you talking about? They just would have run with it.
so there's so many levels of this, right? What does history actually mean, right? It's like when they say someone has criminal history. What does that mean? Is that an arrest? Is that a conviction? Is that something sort of in between there? Because those details matter quite a bit in how a court should use that information. Yeah.
Do you have the right to ask them to produce the evidence to support that?
Yeah.
And if they don't, what is my next recourse for that?
So I think so the example of the grandmother who is denied, who they say the kid can't place with the grandma because of CPS history. The grandma, so there's two ways. One, you can go to the court and ask the court to issue an order that DHS produce it. And the argument I would make is they are saying that this child cannot go with this relative. There's sort of this presumption in our law that kids go with relatives. Before they can make that determination, or you can, we all need to know this information, issue an order to produce it, or else this case can't move forward. And that's how we got the order in my case. The other way you can do it is the grandma is entitled to her own CPS file, and that's in the DHS's own policy. So we also went straight to grandma, got her to sign a release, and so she went to the agency, got a copy of the file, but then we could have also followed up directly with the CPS worker with the release to get that information. Without the court order, though, and without the release, you can't just go as like the parent's attorney to CPS and say, produce grandma's CPS file. the CPS should not give that to you because of confidentiality issues. I had a hand up.
Phrase, use it, it's really good. Policy mythology. For the most part, the people say policy when it means I don't want to do it.
Right,
Mm-hmm.
right.
And they can't produce them. Majority of time, way over majority of the time I've asked for policy, because I know, and Tracy and a lot of people in the military, they do. I'm telling you, especially private agencies.
There's a hand over here. Yeah.
I have a question about this issue about the criminal record check, about it, it's not required on a relative, because I remember early on when I was representing both parents and kids, and I was representing a child, and I went to the home of a relative, and come to find out she had been convicted of murdering her prior husband. I mean, what protections are in place to make sure that, that this is not putting the child at further risk by putting them with a relative? What if they have some kind of background where they've done something harmful to children in the past?
Yeah, so this is going to be, so when I say the criminal records do not have to be done, legally, judges have the discretion and the authority to place kids in these homes without doing this check. Now, practically, will judges actually do that? Probably not. But I want to make sure that we know that if, for example, they may order a criminal check that to be done, and then like weeks and weeks and weeks have passed. I think as a sort of a group of attorneys, we need to know that legally under our laws, it's actually not required. It's not a condition precedent to making the placement. Now, there may be situations, maybe it's best policy for a judge to order it, and if that's the case, then what I would do in any case is set time limits, right? So if there's a relative out there and the department says, well, we need to do clearances, then I think we need to start asking for a fine. And you know, they have to do it within 24 hours, within 48 hours, within the same day. This is all stuff in this day and age of technology. There's no need for that to take long at all. And so even though, so that slide up there is just purely under our laws. It is not required. They don't even have to do a home study under our law before a kid can be placed with a relative. They have something like 30 days, or there's a time limit in the statute. And 7 days for the criminal history. And so you can place, so I think what our law creates, and I think this makes sense because there are going to be situations where a court, based on everything they know about a family, and it could be a rich history of, you know, different mom and dad and the worker saying this all seems good, for them not to have to send this child to a licensed foster home while the bureaucracy sort of gets its stuff together. But in a case where you don't know much about somebody, then the department may move a little bit slower. But I still think we should attach time limits to what the department wants to do.
Statutory placement standards have one up in 9548, and all it is fit, willing, and able to care for the child's needs. That's
Right,
the
I
relevant
mean,
placement standard.
I think, you know, if a person is a jurist, it's not that they have a criminal background, because they may have something that may not be harmful to the child. I just would want to know that.
Yeah,
before-
no, I agree with that. I just think that one thing, one is the time limits for me. Like, we just need to make sure that they do them quickly. And that there's various ways to do it. One, you could ask for a specific deadline. You can ask for a specific deadline and then a report to the court and all parties about what the results were. You could ask for a follow-up hearing within a couple of days. I mean, there's sort of various tools that we can use to make sure that things are done. What I wouldn't want to see done is that set up as a requirement and then no follow-up, because I worry that they would just sit on it because of, you know, emergencies happening and whatever that may be, and that gets lost in the radar, and these kids remain in stranger foster care as a result of that. So we have placement. Parenting time is another sort of big issue that you want to deal with at the preliminary hearing. You can sort of look through the statutory standard. Remember that the right exists even if the agency is seeking TPR at the initial disposition. There is a change in our law. It used to be an automatic presumption of a suspension unless the parents' attorneys and the parents could rebut that. That is no longer the case. There needs to be a showing of harm before you suspend visits, that even if visits were supervised, it would be harmful for a child. Things like non-compliance with a service plan is not a showing of harm. You know, a parent who tests positive for drugs is not a showing of harm. You need to show that the harm of the actual the child would be harmed during the actual visit itself. The other thing is the presumption of supervision. That's something that's just sort of has emerged as part of our culture in child welfare. And I think as we're asking questions of sort of like the toddler style of lawyering, is just asking why all the time, right? So if visits need to be supervised, well, why? Well, if it's a dirty home case, can they be unsupervised in the community somewhere? Can they be at a park together? Can they, like what is the real harm that we are trying to prevent? You will see all the studies indicating that reunification, the parenting time is just crucial to reunification. That the more kids can see their parents in more natural settings, the more likely it is that kids will go home. Tracy?
Vivek, I just want to make a comment. I'm so glad that you're using the term parenting time, because what I find frequently in juvenile court is this term of visitation
Yeah.
used. And I hate that, because it's all about parenting time and not visitation. I think that really goes towards shaping what is really occurring. It's parenting time, not visitation. I do a lot of family court work as well. So I think that can go a long way in terms of shaping not only the Department of Health and Human Services view of what's occurring between the parent and child in terms of preserving that bond, but also the court and all the parties that are involved.
Yeah, and parenting time goes beyond just sort of the physical sort of meetings at DHS or in the community, but it also means the parent going to conferences at school, going to medical appointments, things that we can do to keep our parents engaged with their children. The more we can do that, the better. So this is where I think with parenting time, particularly, our policies with the department are great. They are really, really, really good in terms of how much parenting time children and parents should get. So this is just sort of, and I know this is a lot of text for a PowerPoint slide, but I wanted to sort of block all of this stuff because it's just so good. The more frequent the parenting time, the more likely the child will return home. The supervising agency, I like this one, right? The supervising agency must institute a flexible schedule to provide a number of hours outside of the traditional workday to accommodate the schedules of the individuals involved. That is from their own policy, right? So the next time we hear, that we cannot do visits because it's on a weekend or it's the evening, they are violating their own policies. They are, and there's actually a statute that I have the site coming up as well that says exactly that, which that the agency has to accommodate a non-traditional schedule. And if their bureaucracy and their structure hasn't reformed itself to accommodate it, well, they have to. And so, so it's one of those things that I think we need to be citing more and more, their own policies on these issues. Yeah.
What recourse do you have if they don't accommodate?
So I think the resource we have is we need to file a motion, set the law, seek a court order, and then use the appellate process if we need to, although it's a lengthy process. But I think we just need to start doing that more, filing more applications to the Court of Appeals.
Is the private agency consider doing a complaint to DECAL?
Yep, because private agencies are still bound to follow all of this stuff. The buck stops with DHS. They may have their own policies in addition to these, but this is a basic minimum set of policies that every private agency has to.
DECAL, Bureau of Children and Adult Licensing, which the private agencies are bound to follow DHS policy, the Modified Settlement Agreement, federal and state law.
Mm-hmm.
They might use the private agency.
And if they
Correct.
don't do, make a complaint.
So here are more, so that's the statute right there that's never cited in juvenile court, 722.954B3, that plainly states that the agency has to accommodate hours outside the traditional workday to have visits, something that's often a problem. So look at that, so timing per week. In some counties, are most counties doing this now? Are they following this? So for babies, 0 to 2, 3 times a week. This, I think, no? Who said no? You said no? Tracy said no? Okay, so this is straight from DHS's policy manual. It has, I think, Kim, I don't know if you'd agree, but I think it's dramatically changed things in our county because the agency is doing this. And it is, I think, as you reflect back, this is something that Director Corrigan had really pushed for in her, sort of the end of her term as DHHS director. And I think it's sort of a radical change from what it was 4 years ago in most places, which is once a week. And you had to really fight for visits happening more often than that. And now, for many kids, they're seeing their parents multiple times a week, which I think is exactly the way to go. If you're in a county where they're not doing that, you just got to, cite, file a motion, and try to get that issue litigated. This is again from DHS's manual. Parents should be involved in activities, planning for the child, school conferences, medical, dental. If they're involved in church activities, get them there. Figure out what this family was doing together, and see if you can keep that involvement alive. Because what we want to try to do is just remind that parent that they are still the parent. Because if you talk to parents of kids in foster care, they will often talk about how humiliating it is because they're not treated as a parent anymore. And their child is not only removed from their physical care, but they are they're treated like strangers, and we are making all these decisions about their child, even though we want to reunify them with their child, but we're not telling them about appointments. We're not telling them sort of what the sort of the day-to-day stuff that they were doing prior to this.
Is this a part of FOM 722?
Yes, all of it is. Yep, everything about visitation is right in there. Incarcerated parents. This is another issue that is huge in our state, right? It could not be clearer in DHS's policies, in Mason, which is a Michigan Supreme Court decision, that the same standards for visitation apply to incarcerated parents. Same exact ones, that in order to suspend visits between an incarcerated parent and a child, you have to have a showing of harm. It is not enough legally to simply say, the client is incarcerated, therefore visits should be suspended.
They would say the child, it's harmful for the child to go. I mean, I go
Yeah.
sometimes, there's all kind of kids in prison.
Yeah, absolutely. There are,
They can catch scabies.
and so I think this is an issue that, so there are certain issues like that if there's a suspension of parenting time simply because a parent is incarcerated, you as an attorney should consider, and there's folks like me and others who will help, filing an application with the Michigan Court of Appeals. You don't have to, it's not a right to appeal, but you can do basically interlocutory appeals on sort of small issues like that I think need to get litigated. Like, we need a good case at the Court of Appeals that plainly holds that, and we have in Mason, it says it, but it's like in a footnote, or it's not very, it wasn't a sort of a strong part of that case. But it's silly though. Thousands and thousands and thousands of kids in Michigan visit their parents all the time in prison. Those kids just aren't in the foster care system. Now, having represented incarcerated parents, some of my clients don't want their kids to visit them incarcerated. And I get that, that's their right. And obviously we need to talk to them about what we want to do for them in our case. But this presumption though, that prisons are places where no children visit, is just, it's like we're living in a different world than the reality that exists in so many places. Yes, yes. Tracy?
Well, I find it's not so much that there's a stigma attached to the having one parent who's incarcerated, but a logistics issue. If the child is placed, how do we get the child up to the facility?
Yeah.
And
I
really big stumbling block.
but I think the counter argument is that it's a right, right? So in a way, and it's their problem answer, but it's a right. I mean, it's a statutory right that parents have and kids have. It's not just we think of the parenting time and visitation is just like the parents' right. It's the kids' right, right? And again, like the fact that an agency has not figured out how to make this happen doesn't mean that they can ignore the legislator's mandate, right? We are sort of all we are doing when you feel bad about asking for these things, all you are doing is enforcing the law as written. You're not even like taking the next step of trying to expand the law or be creative, tell them to do something that, this is the stuff that our legislature has said we need to do in every case. And everyone else, a lot of people don't want to do it, but we're just telling the court, this is sort of basic sort of, construing a statute. We're just telling the juvenile court judge and the other parties that you have to do what the legislature has asked you to do. Yeah.
I just wanted to add that how do you even know that there's harm unless you try it and then the child is traumatized or some bad thing happens?
And then they have to, they can't just come and tout that, I agree. They have to have a psychological, I mean, this is where this.
Yeah.
There's some case law out there that's kind of backed up the agency saying you can't just make that call, you have to have something to support that.
Our county, I mean, the only clients I've ever had contact or had their parents contact them who are incarcerated have had a strong desire to see their parents. So I have clients who have infant children, and it's consistent. Every referee or judge we have says it's not in the child's best interest to go see a parent that's incarcerated. We don't want to promote jailing. That's what they say. So,
Yeah.
Is that a harm?
Yes.
What do I say?
It's a harm that they have to show that the child is going to be harmed, and if they say it's harmful for a child to see their, I think that's the type of stuff that we can find. There's a great, she was supposed to be here. I don't think she's here today. There's a fellow. Her name is Amanda Alexander, who works at the university, and she's on a fellowship working solely on and looking at incarcerated children and their relationships with parents. I'll get that info because she can get you experts. I mean, like that's the type of issue that then we need to start litigating, because I think there are a lot of sort of credentialed people who will say it's actually harmful.
The child really shows a desire, and they're older children.
Yeah.
So they're not the younger children, and so I have one where they're going to termination because there's no bond.
Yeah. So let's zip through let's zip through the next couple of slides, and then we're going to take a break. So supervision is necessary. Be creative. A lot of other folks in other jurisdictions look for non-DHS supervisors, relatives, foster parents. Here's something that we do not do in Michigan well at all, is bridging that relationship between foster parents and birth parents. In other jurisdictions, you will see a lot more creative work being done where foster parents are working with birth parents towards reunification. Now, this is not something that you can do in every case, obviously, because there are going to be some facts that prevent that from happening. But I think in far more cases than we're willing to admit right now, we could forge a relationship and at least introduce them to one another so they can work together to plan jointly for this child who is in foster care. I can't think of how disempowering it would be if your kid was put into foster care and then you're not allowed to have a conversation with the person who's caring for the child about things that, like think about how much, for those of you who have children, like we obsess over every little thing that in our children's day, from what time they take a nap to what they eat to what they sleep with to, all their routines. And I feel like too often we don't even allow parents to convey or communicate that information, or allow foster parents, if a kid is placed in my care, I'd want to reach out and know that stuff before a kid is with me. Yet I feel like we have this sort of underlying assumption that these folks in our cases are so bad at every little aspect of parenting that they're not worth talking to. And I think the reality is that they have made mistakes, but that doesn't sort of define every aspect of their character or personality, and that we need to start sort of treating them and creating a system where we recognize that people can be flawed in one respect, but also very resourceful and powerful in various other aspects of their life. But I fear that too often we don't necessarily do that. This is a question, and we're going to, I know Tracy's going to talk more about services in her section as well. This is one of these sort of issues, and Betsy had alluded to it, that I think parents, lawyers disagree about how quickly clients should engage in services. My own view is that, what's that? Yeah, it could be. It could be, actually. It's part of an assessment of a case, right? If you think your client could potentially prevail in an adjudication hearing, then perhaps it is worth holding off and treating this case almost like a quasi-criminal case where you're litigating the heck out of it because you think you could win. I think most of our cases, the court-appointed cases, fall into the latter category where if we look at the success rates, just not even judging the merits of your case, it is a very difficult thing to win an adjudication trial. And so what I usually, even in cases where I go to trial, I usually encourage my clients to get involved in services immediately. Now, we can talk about what services those are. Now, would I encourage them to go to a psychological evaluation immediately if I want to go to trial? No, because to me, like they would just introduce that into my trial, and it's very hard to sustain. But a parenting class, some sort of treatment stuff, I think there's risk involved. Certainly there's risk involved, but what I worry is that our chances of winning an adjudication hearing are so slim that I want to get that ball rolling as quickly as possible. It is a conversation to have with your clients. If you want, so the statute says that the agency has to offer services basically immediately. Within 30 days of removal, the service plan needs to be created. Any talk about you have to wait till disposition for services to be offered is just flatly sort of contradicted by our statutes and our juvenile code and best practice. If you live in a county and they're like, well, we haven't gotten to disposition yet, we can't provide services, that is just, the fact that the service plan needs to be created within a month of removal, I think is proof in and of itself that, that services have to be provided right away.
No exception for aggravated circumstances case or request for immediate termination in the mandatory ISP.
Right.
So they can't just say, well, we're going straight to termination, we're not doing an ISP.
Although, so I think what Betsy's alluding to is that there are certain cases that talk about when reasonable efforts need not be provided in our statute, and those are called aggravating circumstances cases. But sort of in the vast majority of cases, you can ask. What I would do is, if your client really wants to engage in services, which I hope they would be, you can ask courts to order the agency to provide those services. The court will likely not make it mandatory at all before adjudication, just out of sort of equity principles, like if there's sort of a dispute about whether something happened. But the court certainly, from my experience, has been willing to order the agency to provide them right away, because that clock to permanency starts ticking right away. At removal, that 15 to 22 months, which we'll talk about when we're talking about termination, that starts right away. That any delay is just going to hurt your client. And just looking at the odds are, as a group, maybe after today it'll change, but we're not highly successful at adjudication hearings, right? So we cannot plan all of our cases in this we're going to win at trial mode, because that's just going to eventually hurt our client. Now, we'll talk a little bit more in a couple of sections about how we might be able to do adjudication trials a little bit differently and better to perhaps make us more successful. But even then, it's a hard standard. It's preponderance. It's a vague legal standard. And so I would encourage folks to try to get clients to do services.
May I just add?
Yeah, please.
Now the agency is saying they won't pay for things, they're trying to go through your own insurance plan. And so you might want to get an order. I just found this out about substance abuse treatment, even after ISP
Yeah.
is done. So,
The feds won't give us any more federal funding if we keep doing that. There's federal regulations. Kelly may know more about this than I do, but they have to fund. The state has to fund the reasonable efforts.
I will say that this is an issue not just in Michigan, but across the country. There are certain big jurisdictions that do not pay for services. And so I have seen certain judges in orders saying DHS shall pay for all services if other sources of funding do not cover services. So it's always saying, go to your insurance first, go to Medicaid, whatever, but in the end, the buck stops with DHS. I think it creates a huge reasonable efforts issue if a service isn't provided by the agency. When it comes time to TPR, they're sort of going to create an issue, because if they haven't provided the services, I think that's one of the defenses that we will have to say that TPR should not be.
But to speak to your issue about the clock is ticking, I didn't even know this was going on until a client said to me, well, I'm looking for a substance abuse treatment facility that'll take my insurance. I said, well, why are you doing that? And meanwhile, reviews, 90-day reviews, ticking off the clock, and so
That's a great.
just as a matter of fact,
It's a great observation.
order, or like if they want services earlier, ask that in the order that DHS be.
Yep. And then every review hearing that you have where the service hasn't been provided, or a client's looking for it, but we got to document that stuff and make sure that, so that way you're giving the TPR lawyer and the appellate lawyer the sign that there's an issue here. That this is an issue where a parent didn't want to do something. It's
More and more obvious cases too.
yeah. So we talked a little bit about reasonable efforts before. This is yet another finding. I think the key is making sure they are real efforts. There is a huge cost for if the court finds that the agency did not make reasonable efforts, in that the agency loses the right to get federal reimbursement for that child's stay in foster care for the entire duration of the case. So it is a big, 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 huge deal. If you want to see the agency moving, if you file a motion in a case asking a court to make a no reasonable efforts finding, oftentimes that gets supervisors at court, gets various people, because there's a financial penalty that could be imposed as a result of it. So it's just one more tool that we have. DHS, that particular section of the foster care manual, 722.6, is just probably the most useful. If you were to look at one thing in their foster care manual, that's what I would look at. Those are just examples of different efforts that can be made. How do you challenge it? Object, raise the issues, findings. We just need to at least start having a conversation in courts about this, because I feel like right now findings are being made by clerks sitting there and typing them out without us ever even talking about the issue in court.
Where I found out the most mistake is created because they put in their computer what they're thinking about referring people to, because it's a computer-generated boilerplate plan. And so they did those services on there, but they were never applied to that client.
Yeah.
And so that's why the list looks so long and it's so wrong.
You mean in the parent agency treatment plan?
Yeah, I mean,
In the court orders.
Efforts section of the petition. And
Oh, I see.
Of the court findings on reasonable efforts. Those come right out of the CPS petition. They're replicated, I think, probably in everybody's orders to the reasonable efforts paragraph, and then becomes the law of the case. And they come out of a computer-generated thing and the computer system that says, oh, this is a domestic violence case. Plop out all these things we probably did, but didn't do.
Yeah. So we just need to start asking all the follow-up questions.
Where are you seeing that? In order or
In the petition is, I think, what Betsy's saying. All right, so I'm going to quickly go through there are entire day-long trainings on MIFBA and ICWA. I just want to make sure that all of you, especially the newer folks, know these statutes exist. So the MIFBA is the Michigan Indian Family Preservation Act. It is basically the state equivalent, or the implementation statute, of the Indian Child Welfare Act. At the prelim, you just want to err on the side of being very cautious and overly inclusive, in that if your client has any indication that there's Indian heritage, raise it on the record. The court's got to provide notice to the tribe, to the Department of Health, to the Secretary of the Bureau of Interior if they don't know who the tribe is. Nothing can really happen in the case until 10 days after receipt is received, that the tribe or the secretary received notice. And then it changes drastically if the child is Indian, this whole removal process. I think for the purpose of this training, if your child is deemed to be Indian and you have a removal hearing and you don't know what to do, just call one of us, because all the standards are way higher. It requires expert testimony. Michigan Indian Legal Services is a tremendous resource. I would call them. They know sort of all this stuff.
Yeah, we have a lot of Indian cases, I think, because we have vacancy and other stuff, but the tribal attorneys have given us handouts. So I have them like on my pad, so I can look at the standards, the active effort standards, and what we need to do. And most of the referees are up to snuff. It's the agencies that aren't.
So if you have that information, if you could email that to me, I can make sure that the rest of the group gets it, so that way we're all.
There's like a flow chart here.
That'd be great. That'd be very helpful for all of us. Yeah.
We are also sponsoring an ICWA conference in December. We believe it may be December 4th, but I'll check on that. And that'll be specific for jurists and attorneys, and then we'll have one in the spring focused on social workers.
All right, lastly, if the hearing doesn't go well, remember that most of these hearings are heard by referees. You have the right under your court rules to ask a judge to review it. How seriously the judge will review it will depend on your county and locality. Some do, some don't. Some just sign their names to it. You can also file an application to the Court of Appeals if you want review of any decision ever in a child welfare case. An application is not a right to appeal. You only have the right to appeal in a child welfare case of basically two decisions: the order of disposition, which includes the adjudication finding and all that, and an order terminating parental rights. We used to think that it was a removal order, but there was a decision, I think last year or the year before, that held that a removal order is not appealable as of right. It is appealable by application. That all an application means is that the Court of Appeals could say they do not want to review it, but then you could go to the Michigan Supreme Court and ask that they review it, even if the Court of Appeals said they not want to review it. In fact, In re Sanders was a case that was filed on an application to the Michigan Court of Appeals first. The Michigan Court of Appeals said they didn't want to hear it, and so then the Supreme Court said they did. And so you do have that. So any of these decisions about parenting time, whatever that may be, you can ask for an application. Some of these will be easy. It'll be like a little short transcript, and we may just want to start doing that more just to get the Court of Appeals small, discrete issues. Again, if you want to appeal something, that's a whole separate training that we had a couple of weeks ago here. But there are ways to speed up the appellate process on some of this stuff. So there are different motions you can file on issues like visitation and placement that we could file just to get a quicker decision. So it could be a tool that we use.
I just am always puzzled by how an order removing a child from a parent does not affect custody. And the orders that affect custody under the appellate rules are final orders appealable by right. Was that raised in that case?
I don't know if it was raised. Yeah, I don't think it was raised in that case.
It was domestic relations statute, so nobody raised it.
Yeah, I think that's right. So we should talk more about that because it could be something to revisit. All right, so we are going to take a 15-minute break, and then we're going to skip the simulation part of it because Tracy has some stuff built in, and then we're going to start with Tracy's section next, which is really going to look at the next 60 days of the case.